Good afternoon, everyone. Thank you so much for joining us today. We have a great training for you discussing how to reframe your request if you've been denied with a FOIA request, and I am excited to hop into what we're going to be covering today. So we're going to be discussing what a denial might look like, how to narrow your FOIA request if you get a denial, language to use in your request. We're going to practice some responses to denials, and then we're going to talk about what legal action might look like, and then finally end with an open Q&A. So you have three amazing experts, speakers who are going to be talking to you today. We have Cam, who is a data reporter at the Illinois Answers Project. Cam is interested in the overlap between community engagement, investigative, and data reporting. And Cam has done everything from research and archive database digging, creating graphics, interactive visualizations, editing and management, engagement strategy, public requests, and more. You'll also be hearing from Jim Daley, who is an investigative journalist and senior editor at Southside Weekly, where he helps run the paper's Community Investigations Hub. His investigation of how Chicago police surveilled protesters during the George Floyd uprisings won the 2021 Lissagore for the best in-depth reporting in community newspapers. And he has previously worked as a news editor at the Chicago Reader and the Tribe. And lastly, today we have Matt Topic, who's a partner at Loevy and Loevy, has litigated hundreds of state and federal FOIA cases around the country. He's trained hundreds of journalists, activists, lawmakers, and individuals on the Freedom of Information Act, and is a regular presenter in investigative reporters and editors conferences. He's frequently quoted in the media on transparency issues. He has represented journalists seeking access to court records and defended and counseled against defamation claims and fought unconstitutional gag orders. So with that being said, I'm excited to kick off this training with Jim, who's going to start by discussing what happens when your FOIA request is denied.
All right. Thank you very much for that great introduction. So welcome, everybody. I'm really excited to see so many people here, as well as like a full classroom and various organizations that do community work. That's precisely what these workshops are geared towards. So we're very happy to have you all here. Can you just sound off in the chat if you have ever filed a FOIA request? If you have not, just say so as well. Just real quick, just a yes, no, or a thumbs up. Got some yeses. Yeah, okay, several. All right. All right, so everybody's filed a FOIA request, or many people have filed a FOIA request. How many? So, okay, a bunch of students have not. Glad you're here. Hopefully you'll file one soon. If you have gotten a denial ever, can you indicate that in the chat as well? I'm guessing there's going to be a lot of yeses there too, because it is not uncommon. So this workshop is designed to tell us what the next steps are. So can we have the next slide, please? If a FOIA officer is denying your request, at least in Illinois, the law requires that they explain to you why they're doing it in writing. And they have to do that within 10 business days. If you do not either get the records you've requested or a formal denial or some communication from the FOIA officer, occasionally they'll say, hey, I just need a couple more days. That's not really covered in the law, but you can sometimes give them a couple more days. But if you don't get any of that, that also counts as a denial. So what's next? Next slide, please. First, you have to figure out why they're denying your request. And there's a bunch of reasons why they can legally do this. Illinois FOIA law, as well as federal FOIA law, many different state FOIA laws, allow for certain exemptions. So these include if you're looking for private or personal information, medical records, for individuals you can't get through FOIA, as well as for government, if there is anything in what's called the deliberative process, which is when they're coming up with policies, basically, or considering what to do as an administration. Drafts of requests for proposals or policies are not covered and are exempt. Anything that's covered by attorney-client privilege. Trade secrets can also be exempted. Research materials kind of fit into the deliberative process thing. They're a separate exemption, but it's the same sort of logic where they're still trying to figure out a problem, so they're not going to make those documents public. Certain law enforcement records, especially ones pertaining to open investigations, are exempt. While they're negotiating contracts, they don't have to release them under FOIA. And unduly burdensome requests. That's a very common response in which they're basically saying, this is too much work for us to do within the allotted time. So usually they're going to say that the request is unduly burdensome, or they'll tell you which section of Illinois' FOIA Act they are citing as a reason to make these records exempt from FOIA. We have the next slide. So here are some examples of different denial letters I've gotten over the years. These represent different types of denials too. So the first one on the left, I asked for, I don't know if you can make it out, I wanted emails between a guy who works at the Office of Public Safety Administration in Chicago and a ShotSpotter executive. They did not have any emails, so that was simply a denial saying no responsive records. That's not uncommon. And there's nothing you can really do about that as far as I know, because the records just don't exist. The second one in the middle is an unduly burdensome response. And if you see the highlighted portion, I was asking for emails, and they said that it would take 27 hours to review the emails as well as redact them. Now, that falls within the amount of time in a 10-day response window, but they consider it unduly burdensome. And we'll talk a little bit about what to do when you get that sort of response. The third is an example of trade secret, where we were requesting ShotSpotter misreports from the Chicago Police Department, and they said that giving up any information about that would be in violation of the trade secret exemption, because ShotSpotter is a private company and how they collect this information is a trade secret, and so CPD couldn't comply. And we're going to talk about that one later too, and what we did with regard to that. Next slide. Thank you. Cam?
Yeah, so often, like Jim said, what you're going to get hit with in a denial is an unduly burdensome claim. Again, like Jim said, this is a specific legal phrase. It's in statute. And often what it means is that it just is too much for the office to handle on a day-to-day basis, for them to be able to take this request. So either it's like, maybe it's a staff of one, and it would take up like their entire working hours for an agency that gets a bunch of requests a year. Or it could just be, sometimes for larger agencies, a cop-out in an attempt to get you to narrow your request. So often what they're trying to get you to do, again, is narrow your request. In Jim's case here, probably having them or having the requester narrow it to less emails or in a different time frame, and we'll talk about that in a sec. There are legal recourses available that we'll talk about a little bit later as to what to do when you keep hitting this unduly burdensome wall. So narrowing your request, the biggest strategy I would say is like negotiation is always on the table. I put this down here, but I mean, honestly, it should be at the very top, is that FOIA is a two-way street. It is as much a FOIA officer upholding the law, doing their job, as it is you being able to get these documents in a timely fashion, but compassion can always be thrown in as well. Different agencies have different workloads and timelines, and full-time staff and part-time staff, paralegals, like could really just be a very truly unduly burdensome situation for an agency. But the key here is that you are entitled to reasoning for a denial or an exemption for a response you might get back. It has to be quoted in statute. So you can use that to figure out what might need to be modified in your request. If you don't want to do the guesswork, you can always call a FOIA officer. I do that pretty frequently, or I'll just hop on the phone or get someone through the agency. Usually it's, I'll just call like an information line, and kind of get their insight into what situation might be happening in that agency that I might not be privy to because I don't work there, but also, how we can best make it work for everyone, right? If you're looking for inspiration for how to reword a request, which is an exercise we'll go through later in the presentation, I always love to request for FOIA logs, which does make me feel extremely nosy, but kind of getting a feel for how other people are framing the request can be really helpful, especially if you're hitting semantic pitfalls. Muckrock is also a wonderful resource, cannot recommend them enough. Being able to search by agency and search different requests and different types of requests can give you insight into what people are doing outside of Illinois, outside of Chicago. But maybe if they're looking for the same type of document, that can be very helpful. Muckrock's also very helpful for federal requests. So if you are taking it outside of Illinois. In terms of what to look out for, that might lend your request to being shot down. If you're describing the information and not the document, that could be something that a FOIA officer might push back against, because according to statute, you're entitled to the records, but you're not entitled to answers to general queries. So again, if I were to say like, I want, or like, how many bike crashes happened last year on a certain intersection, they could just respond and say like, no, like denied. It is not, like, we're not a general information service. But you could request like, I want police logs for every traffic incident involving bikers from Jan 1 to December 31st, like of last year. And that would be something that you would be entitled to. Any all and every can be a little iffy at times. I think using, say, the phrase like, I want any document related to bike crashes, or I want all documents related to bike crashes, or every document related to bike crashes, that, like, in my mind, and probably in an average FOIA officer's mind, immediately invites an unduly burdensome denial, if not an extension immediately. It might be that they don't know the full scope of the documents that exist. That's a huge part of research and records process. So being able to specify a time frame and potentially being able to specify a file size or a limit, like, for example, Jim's email request, you could always say, I want all of these emails between a certain time frame up to 200 pages or up to 100 pages. And even if it's not the full, the full Monty of what you're looking for, at least chunking it out can help keep you from not getting your documents, but also help the agency be able to process them in a way that doesn't burn your bridge with them in the future. And then the other thing to keep in mind is making it impersonal. You don't want to request for someone's social security number, for example, like being willing to work with redactions, especially if it's information that you don't need. I think is something I at least run into very commonly when I get people and FOIA officers who are asking me to reframe my request. Often they read way too much into the request. For example, for our annual salaries database, I'm requesting for payroll information, and sometimes people are like, why do you want my address? And I'm like, I don't want your address, actually. I just want to know how much you made. And being willing to get on the phone and kind of have that conversation and talk people down and say, like, give me the bare minimum of what I requested for, in some specific cases can be really useful. And PII stands for personally identifiable information, by the way. But yeah, we'll talk about working with the PAC, Jim.
Thanks, Cam. And yeah, before I start talking about the PAC, I just want to reiterate what Cam was saying about negotiating with FOIA officers. It's always good, especially with an unduly burdensome response, to get on the phone and find out how they can structure their response to you. And you'll often get pretty far that way. If you don't, and they are stonewalling you, the Attorney General of Illinois has a public access counselor. I'm actually not sure how common these are in other states, or if there's any sort of federal equivalent to this, just because my experience doesn't go that far. But in the Illinois Attorney General office, this is an office that is solely dedicated to helping with transparency and FOIA requests. So if you go to their website, if you just Google like Attorney General Illinois Public Access Counselor, you'll find this website. And it's got some information, including where to send your requests. And so now we're going to talk about how to send those requests. So if you could do the next slide, please. So this is a sample email that I sent in September of 2020. after the Civilian Office of Police Accountability in Chicago, which is a police oversight agency, denied my request for body cam footage. Now, the reason that they denied that request was because COPA was investigating the incident that these videos were related to, and they were basically saying that it would interfere with their investigation if they released these body cam videos, which were an attachment to an email. So the first thing that I did was send this email. You can see in the attachments line, there's a few attachments to it. So I included the first response letter that I got from COPA denying my request, as well as the attachments that I had sent COPA to ask for the request. And that was just to give them information about, like, this is what I'm requesting. So you want to make sure that you include all of the relevant correspondence. So you want to attach your initial request, you want to attach any extensions that they've sent, and then you want to attach their denial. Anything else that you can attach that can help the PAC, just giving them more information, is not a bad idea. They might write you back and say, hey, we also need this email or that email. So it's good to keep your files organized. We talked about that in the first edition of this workshop, or the first episode of this workshop, which is also online if you haven't seen it. So this is the initial response that I got for that. So I sent it on September 16th. On September 23rd, what they did was reach out to COPA to request information from them. Basically, the PAC gets to ask COPA, who denied my FOIA request, for the documents so that the PAC can review them and determine independently, are these exempt under FOIA law, or is the journalist correct here in this request for review? So that was in September of 2020, and that's what they sent to COPA. This is their determination letter that they sent after reviewing the case. There's a bit.ly link at the bottom of your screen. If you go to that, you can see the full letter because it's several pages long. But ultimately, the relevant portion begins on page 2, in which they have determined that the FOIA officer did not meet the burden for withholding records. So this is a success story. However, note the dates. So I initially sent my request in September of 2020. They're now getting back to me in June of 2022. This was a bit of a special case, I think, because number one, the COVID pandemic had limited their in-office work, and they were not able to get back to me as quickly as they otherwise could, is what they said anyway. And then also, too, I think this was probably a pretty thorny case, and it took them a while to make their determination. But they ruled in our favor. Can you go to the next slide, please? However, in the interim, while we were waiting for the PAC to make a determination, we reached out to Matt Topic's law firm, and they filed a lawsuit on our behalf. And the lawsuit was able to force COPA, a judge forced COPA to release some of the documents that we were asking for. And you can see in the header image of this article, this is one of the documents we were asking for. I mean, I've put several of them together, but these are stills from body cam images that showed the altercation that a police officer had with an activist in Grant Park in 2020. Ultimately, shortly after we published this story, the officer resigned from the force because it was looking pretty clear that the police board was going to recommend he be fired. So we got these we got what we were looking for before the PAC produced its final determination. That gives you an idea of how long it can take, and it also gives you an idea of the fact that you should there's many paths to Rome, so to speak. You do not necessarily have to wait for the PAC to make their determination. As Matt will talk about in the legal section, having a PAC's determination can be very helpful when you do ultimately litigate, but in my estimation, the newsworthiness of this story and the fact that I just didn't know how long the PAC was going to take made it worthwhile to go the lawsuit route while we were waiting for the PAC's determination. Ultimately, the PAC gave its determination, and we got all the slides we were looking for, but we had already kind of had them at that point. So the next example is one in which the PAC was much faster. So this was in December. I sent a request to the Chicago Police Department for records sufficient to show when they reported missed gunfire to ShotSpotter. Just as an aside, ShotSpotter is an acoustic gunshot detection company that has sensors in police districts in Chicago and in other cities. As part of their contract, the police department is required to inform ShotSpotter when they have a report of a gunshot incident that they don't have a ShotSpotter alert for. So I was trying to get those. CPD denied this request, citing the trade secrets exemption. They said, if we give you this information, that's going to tell ShotSpotter's competitors about their technology, and that counts as a trade secret. And I disagreed. So I sent an email to the PAC, and they got back to me very quickly and sent this letter to CPD asking for the records so that they could review them. In what had never happened before, the CPD responded to that by simply complying with the request. They then said, it's still unduly burdensome because we report these through emails and there are hundreds of emails. Now, the PAC, and Matt can talk about the legalities of this a little more in his section, but the PAC said, unfortunately, because your trade secrets denial was improper, you're not covered by the unduly burdensome one, and you still have to produce these records. But it was 750 lines of data. So what I got around, or so sorry, 750 emails. So I got around that by calling the FOIA officer and having a conversation with him, and he agreed to give us the email metadata, which is just a spreadsheet showing like subject, sender, recipient, date. And from that, we were able to build enough of a picture to report on it. And if you go to the next slide, you can see the story that we got out of that. That was only one part of the overall story, because we also relied on internal ShotSpotter emails that we had gotten through a non-FOIA route, and data analysis and some on-the-ground reporting. But this was a key piece of the story that really added context to a specific example that we had. And so this was a PAC success story where they agreed with us and we got the records that we needed just in time. We actually got the metadata like 3 days before we published the story, and we've been working on it for 3 months at that point. So it was really timely, and I urge you to read that story. We can go to the next slide. So based on what we've just told you, which is a whole lot in a brief period of time, we're going to go into breakout rooms now where each one of us will sort of discuss these kinds of scenarios and see if you understand basically what to do in each of these situations. For the first one, Cam, do you want to take the first one, the unduly burdensome? What would you do if you got an unduly burdensome response? What's the first thing?
Yeah, I mean, one of the things that we talked about in our breakout room was, well, we talked about accessibility. That was a big one. But in terms of unduly burdensomeness, my biggest strategy is just negotiation. I am constantly, constantly getting FOIA officers on the phone. I'm pretty sure in the office, people don't like to sit near me because I'm constantly on the phone. But yeah, I think working with the statute that you're given and working with the exemptions that they give you and the legalese that has been shared, using that to your advantage to then say, okay, how does this fall within this box? And if it doesn't, or if there's a little bit of overlap where it doesn't fall into the box, like what leeway is there for me to be able to leverage that into a response that's beneficial for me? But what about, Jim, how did your group handle no response or response you disagree with?
So those kind of fall into the same bucket effectively, because they're both improper denials if we're correct in disagreeing with them. And so with the no response, like we're also going to call to see if we can get anybody on the line to talk to. But barring that, we are going to contact the PAC right away, and we're probably also going to contact Matt Topic or one of his colleagues to see if we should start litigation now, which we'll get into that process next. But in both cases, we're not taking no for an answer. We're following up with the PAC and with our attorneys. So yeah.
I have a quick question. I don't know if I could jump in and ask.
Sure.
So I have a situation where I received a FOIA that stated on the documents attorney-client privilege and consult an attorney before you release to the public. For me, I'm like, well, what do I do with that? In my opinion, should be something that can be released to the public. If you released it to me, you should be able to release it to the public. So what do I do? Do I not release it or contact an attorney? Is it really attorney-client privilege? Was this a scare tactic by the organization so that I would not, release that information? So just curious about that, because that's sort of like, it's a response I don't agree with per se.
Can I
Matt?
ask a
Sounds like a
question?
legal question.
Yeah, can I ask a question? Did they produce documents to you and then ask to get them back? Or this is what they said when they gave them to you?
They sent it and stamped on the attorney invoices. This is a school district. They stamped on the attorney invoices, attorney-client privilege.
Okay, but they gave them to you.
But they gave them to
okay.
me, yes.
I mean, in general, like no one can stop you from releasing anything that was given to you under FOIA, even if they later claim that they shouldn't have, or that they were allowed to withhold it. There could be some circumstances like national security or like student records or things where there might be liability if you release records, even if, you got them under FOIA. But I think for the most part, courts are saying that if you didn't do anything wrong in obtaining the documents, then you're free to do with them, as you see fit. So that's sort of a strange one. I've seen it more where things get released and then they try to claw it back saying, we messed up, we shouldn't have given this to you. Can we please have it back? And in most instances, you're free to do whatever you want. In some instances, you might want to think that through a little bit more. But again, that would be like national security or things that are like very specific, not things like attorney-client privilege.
Yeah, to me, an invoice going back and forth from a school district is not considered attorney-client privilege if it's dealing with payment.
There could be some pieces, if it's an invoice that has the individual billing entries for each piece of work that was done, then sometimes those descriptions of the work might have information that is properly privileged. But the amounts, who was billing, what matters they were billing to, that's all stuff that's clearly not privileged.
Okay, thank you.
I will say before we move forward, and Jim, I don't know if you've run into this before, especially with the salary requests that I mentioned for the database. I've had documents where I have sent them back because they've been unredacted or redacted very poorly, where I've had social security numbers sent to me. I've had, addresses and like all that. Like, I don't need that. I don't want it. And I've then sent messages to the FOIA officer saying like, I'm not sure if you were aware, but you sent this to me. I deleted it off my computer. Please resend me a redacted version. But if you are, I agree and defer to Matt. I think that they can't stop you. Like, if I had bad intent, they wouldn't be able to stop me from sharing those documents, but I don't want to do that. So
all I will just add is like, there could be some instances where it's actually illegal to disclose certain information. That's not going to be attorney-client privilege, but something like someone's social security number, it's possible that regardless of how you got it, disseminating it further you might have liability as a result of that, but that's going to be very limited.
So this leads right into, I think, the legal section. And we'll start with the FOIA fees, just because Matt has the most experience with that. I've very rarely run into fee requests, and it was in Louisiana. So I don't have a whole lot of Illinois experience with that. You want to take it away?
Sure. Yeah, this doesn't come up very often anymore, honestly, because things are digital, or if they're paper, they can be made digital. And so agencies are allowed to bill you up to 15 cents per page, but it has to be a reasonable estimate of their actual costs. So in theory, that could be less than 15 cents a page. I always just ask for PDFs, and if they're paper copies, I just ask that they scan it. And then they can only charge you for something that approximates the the pro rata like depreciation of the machine that they used for scanning. There's no paper and there's no ink, is what I'm getting at. So in practice, if you ask for electronic copies, you're not going to get assessed any copying charges. Illinois does not provide for any fees other than copying charges unless you're a commercial requester. And commercial requester is a very limited universe, and it's more narrow than just business requesters. It has to be for a specific kind of purpose. Like you're asking for a list of names to send out a mailer, or you're gonna resell the information that you get. So, and it's expressed that journalists and nonprofits don't apply. So you're never going to get charged with like the costs of like searching for records or reviewing records. There are some quirky provisions around recurrent requesters, which are people who make a lot of requests in defined time periods, or voluminous requests, which is sort of a cousin, so to speak, to undue burden. And there can be charges like based on the volume of data. But again, if you're nonprofit or you are journalists, then those provisions don't apply to you. So in practice, fees really don't come up very often. I think I have one case where there's a question of whether someone qualifies as news media or not, which then in turn informs whether they qualify as a recurrent requester, and then in turn implicates some other fees. But in that, a discussion of who is or isn't media is more than we could cover today. But it's in that instance, it was someone who he was a one-person shop with a website reporting on what was going on in his town. And so, that for the purposes of FOIA is a media organization. I see a question here. What if they insist on charging you for PDF email FOIA requests on basis that their attorney had to review? Yeah, no, they're not allowed to do that. They can't charge you for the costs associated with reviewing the records. Again, unless you're commercial, and even then it's only the cost, I think, for searching, and it's only $10 an hour, and no attorney's going to work for $10 an hour. I can tell you that, right?
Well,
so that's fees.
Of legal stuff.
Yeah. So what does legal action look like? So, you have really two options negotiate, try to embarrass them, tell them you're going to write a story about how they won't turn any records over. You have all those kinds of informal things you can do. Jim and Cam also talked about the Attorney General's office in the PAC review. So just quickly, my thoughts on that would be, it is an option, but typically they will only issue non-binding opinions, which the public body doesn't have to follow. And if they don't, you're right back to where you started, and you might have waited months or even years to get to that point. And then they do take a long time. I think generally they come to the right answers. Sometimes on tricky questions, I don't necessarily agree with them. And I've had instances where people have gone to the PAC and the PAC says a withholding is proper, and we file a lawsuit and the court says it was improper. And I think from time to time it can go the other way too. So, but if litigation isn't an option, it can be a viable technique. I think it can be very helpful for just public bodies who aren't responding, because what will often happen is you send it to the PAC, you say they didn't respond, and then the PAC sends the letter to the public body, and then the public body just answers your request instead of having to deal with the PAC. So it can be useful for that. Or sometimes I advise people to do that if I can't quite tell, like if I think maybe the public body's justified, maybe they're not, but I don't understand their position well enough, then sending it to the PAC can be a way to like flesh that out more and get a better understanding of exactly what they're going to argue, so I can evaluate, is this something that we could litigate or would want to litigate. Make sure you pay attention to the deadlines. They're strictly enforced at 60 days. And if it's based on a failure to respond, it's whatever the deadline to respond was. That's day one, and they count it from there. So important to keep that in mind. So option two is you can file a lawsuit. So real important to know, you do not have to go to the PAC before you can file a lawsuit. Like in federal FOIA, you have to do an administrative appeal. It's still within the agency. It's not outside the agency like the PAC is, but you can't file a federal FOIA lawsuit if you've been denied unless you first go through that administrative appeal, which takes time and is kind of a hassle. Illinois got rid of that in the 2010 amendments. You don't have to do any sort of appeal anymore. So if you do end up in a lawsuit. And there's some people on this Zoom who I've represented in lawsuits. A few things that are kind of important to keep in mind. It is the public body's burden to prove the exemption claims and to prove that they did a reasonable search. So if they tell you they don't have any records, but you think that maybe they do, then the mechanism is really to argue whether they did a reasonable search to find the records or not. We have lots of cases that involve that, where they're just, the searches are too narrow, or they're misinterpreting the request, or they didn't do the kind of search we thought they should have done, or that the documents are withheld under an exemption. And then then the public body has to prove it. It's a clear and convincing evidence standard, which is higher than a regular civil case, but it's not quite to the level of beyond a reasonable doubt, is everyone probably knows for like a criminal case. So it's a presumption that all records are subject to disclosure unless the government body can prove by clear and convincing evidence, and it's got to be detailed and it's got to be specific to the documents, that the records are exempt. So a good example would be like ongoing police investigations. It is not enough just to say there is a ongoing investigation. They have to prove that it would interfere with the investigation to release the records, and they have to do that document by document and really line by line. They can't just say there's an open investigation, therefore your request is denied. But that's what the Chicago Police Department does. It is a matter of routine. So anything like that, it's a good chance you're going to have to fight them. But our track record is pretty darn good when it comes to challenging those. Sometimes we lose, but usually we win. There's a thing called in-camera inspection. In-camera meaning the court reviews it privately, something you don't get to see. So a common thing that happens in these cases is the court actually looks at the documents. So it's a mechanism to just sort of keep the public body honest and to get another set of eyes on it. And the court decides it under what's called a de novo review, which means there's no deference to the agency at all. They're starting over from scratch. Has the public body proven what they have to prove? And then the last point here, which is how I'm able to represent a lot of journalists and nonprofits and others, is if you prevail, the public body has to pay your legal fees. And so that allows us to represent people at very little cost, or very often at no cost at all. We basically say, you let us recover any fees we can recover. We don't bill you anything if we lose. And if we lose, then we lose. So it's a very important part of the statute. And there have been studies that have found that the number one predictor of how effective a FOIA statute is or is not is whether there's mandatory attorney fee recovery for requesters who prevail. Because if there isn't, then they can walk all over you, and you really don't have a lot you can do about it unless you're going to spend tens of thousands of dollars of your own money to litigate a FOIA case. Not many people can do that. Even for-profit newsrooms have a hard time doing that. So it's just a very important part of the statute, something to keep in mind.
On that note, it's Q&A time, the best time for these workshops. So if people want to share questions they have in the chat, we will make every effort to answer as many as we can, being mindful of time. If you put them in the chat, it's often like we can try and respond to them like Jim is doing, while we answer other questions as well. But let me get my chat up.
Yeah, so one of the ones I was responding to in the chat had to do with a records retention schedule. So correct me if I'm wrong, but I'm under the impression that all agencies are required to keep a records retention schedule, which just says these are the records we retain. And they're also required to produce it upon request. Is that correct, Matt and Cam?
Yes.
I think it's a matter of the Local Records Act, or for state agency, the State Records Act, that yes, their records have to be retained or destroyed pursuant to a written policy. And there's something called like a local records council or something. It's like the state archivist, and like it's specific people sit on this board to approve retention schedules. So most public bodies will have something that says, like that this kind of record is kept for this long, or it's kept until something happens. Mm-hmm. Some records are considered like transitory, like if it's an email that just says, can we meet at 3:00? I don't know that actually has to be retained at all. But the records retention schedule is a public record, and I can think of no reason why it could be withheld under FOIA. It's possible the Local Records Act has some other like affirmative disclosure obligation for that. But if you're being told that records were destroyed, then it's a very good idea to ask for the records retention schedule pursuant to which it was destroyed, so you can see whether it really was properly destroyed or not.
Great.
In line. Oh, sorry.
Go for it.
I was gonna say, in line with that, I just saw a question from Sarah, which said, if we're at the stage where we want to better understand how to frame and reframe a request, you recommend that we request a FOIA log or search on Muckrack. Could you say more about what a FOIA log is and where or how we could request it? So a FOIA log is essentially it's just a list of all of the FOIA requests that are being requested by requester. I'm going to keep saying request way too often. I'm so sorry. But it is not a formal classification of document like a records retention schedule. No, I don't believe. But it is typically, I mean, like good records custodians will keep a FOIA log. So all you have to do is literally request FOIA log to any agency. You say like, I'm looking for a FOIA log. Typically I give a time frame. I say like for January 1st, 2023 until December 31st, 2023. And a FOIA officer should understand what that means. Now, if you wanted to break it down a little bit more, you could say, again, like a log of all FOIA requests to this agency. It might take some time if they don't have like a ready to go Excel spreadsheet or database going. They might just give you like redacted email requests. I've received that sometimes. But a FOIA log essentially shows you all of that, kind of what Jim was describing with emails, like metadata, right? It shows you the person who filed a request, who, like what the status of the request was, what day they filed, what day it was closed, typically sometimes, and then a description of the document. So most of the city agencies have FOIA logs actually like on their website, which is really helpful. And I can grab a link for it too and share it in the chat. But that's a good sense of like what a FOIA log is and like where to find one is through, if you just look like any city agency's website, they typically have it. Of course, any other questions in the chat that are poking out?
Let me jump on one here about the investigation is 18 months old and they're trying to like permanently claim that the investigation is ongoing. That's a great question. That's an issue that does come up. I mean, I had a case where it was a murder from 1967 and the public body successfully established to the court that it actually really was an ongoing investigation. But what a court would look at is like, well, what kind of activity is actually happening? Like it's maybe a little bit gray, but like there's a difference between like an unsolved crime and an active investigation. I think then you get into like how police databases work and like when a case is considered cleared. Like it might be that the case remains open. It might be that it's just sort of we've done everything we can and we're done. There's nothing unless something out new comes in. I think in general courts will say like if it hasn't been solved, then even if they're not really actively investigating it, they're probably not going to want to allow the release of anything if the public body can show it actually would interfere with the investigation. It depends on what it is too. If it's, I mean, I've had a series of cases for NBC Chicago on this series called Left 4 Dead, where they're hit and runs that don't appear like they've really actually are being actively investigated. That's sort of the whole point of the series. But typically, we're winning those based on just the inability of the police to prove that it would interfere with any investigation. So I hope that's helpful. If it's like a misdemeanor, like minor thing, like somebody stole something worth $5, then the idea that they're still investigating that 18 months later probably isn't very plausible.
There was also a question about CPD records, and I don't actually recall if they were successful in changing the retention of disciplinary files to like just 7 years. I know the FOP was pushing for that, but I don't actually recall if they were successful. Do either of you?
On disciplinary records more than 4 years old in the police union. Yeah, I mean, I think where that basically landed was if they if they still have them, even if under the union contract they were supposed to have been destroyed, then you still get them under FOIA. But I think there may have been some cases maybe from a different county that came out differently. But
Okay. Also, too, one thing to note is, so with the Office of Public Safety Administration, if you're FOIAing anything from the Chicago police, they may have moved those records or claimed to have moved those records over to the PSA. So what I've started doing is just every FOIA goes to both agencies just in case, because otherwise CPD will take 2 weeks and then tell you we are not the holder of these records.
right.
Just checking the chat if there's any questions we have missed while we have like a minute left here.
Yeah, and I'll put my email in the chat as well if you guys have any follow-up questions. I'm
Sorry.
like locked in trying to respond to some of these in the chat.
Yeah, please feel free to reach out by email.
I had a quick question for Matt, actually.
Sure.
I was asking, what is your process for reviewing potential cases?
Yeah, so anyone can contact us. Like no one gets charged for anything unless if ever you were going to get charged, I would tell you all in advance. So we're happy to take a look at any denials. The easiest way to reach us is FOIA@Loevy.com, which I think I tried to put in the chat. I don't know, I'm having a hard time with the chat today, but so we would just want to take a look at the request and the response and any back and forth. And then, we would take a little bit of time to just evaluate it and see whether we think that the denial was proper or not. And if we thought the denial was improper, then, we have a pretty streamlined retention agreement that generally just says, we'll represent you in this case. You agree that we can collect any fees or penalties under the statute. You don't have to pay anything. And then we kind of go from there. So, I mean, definitely it's helpful if you have your materials relatively well organized. Sometimes we want to know a little bit of context of kind of what does this relate to? Like, is this about a story? Is this an advocacy thing? Like, kind of how does all fit into the equation? But it's pretty simple. And please, everyone, you're not imposing on us. Like, you could send me 1,000 FOIA denials tomorrow and I will look at the 1,000 FOIA denials.
Thank you.
Okay, I think that oh wait, Jim, are you speaking? You can come off mute, you can come off mute. Go ahead.
I was going to say the same thing you're saying, so go right ahead.
Okay, well, I know we're in like the last 2 minutes here, so if anybody has like a final question, you can feel free to unmute and ask. Otherwise, I will be following up with the recording and the slides, and I believe Jim, Matt, and Cam's emails are all in the chat. So yeah, thank you so much for joining today. We'll hang out on this Zoom for the next 5 or so minutes, just to see any other questions. Thank you so much.
Thank you for following up with the recording and the slides, because I was traveling while I was on this Zoom. So I really, really, really need to review everything. So thank you for sharing this information.
Yes, thank you for joining. Definitely.
I will say, unfortunately, some of the questions we're getting are more geared towards our policy team. I wish I could answer some of the questions, but
I have a question.
Yeah.
Just briefly, there was a lot of discussion that took place after the footage for Miss Young was attempted to be retrieved by CBS, but was withheld. And there was that big report that the Jones Day folks wrote. And it seemed to me that was a call to public bodies as well as PAC to improve upon, the release of this information. What are your thoughts about how that has impacted the city so far, and in the request for information, specifically body camera footage?
Yeah, I remember after the video was released, there was a lot of the mayor saying like people shouldn't have to make a FOIA request to get this if they're the person on the video. I mean, it very often, like if it's video that's taken inside someone's home, then there's going to be a privacy exemption or even a specific part of the body cam statute that might block release of it. It's body cam is like it's very intricate in how they set the statute up. So, it's because you could appreciate why, like in many instances, you would need the consent of the person depicted in that video before it could be released. Or maybe maybe their face gets blurred or things like that in order to protect their privacy. So, I mean, I can't tell you that like CPD's gotten any more transparent after that was released. But I think people are more aware of kind of how the body cam stuff works. And I think, I wish I could tell you the city's become more transparent on that, but I don't think I still have lots and lots of cases against CPD for body cam video. It's probably the best way to answer that question.
Okay, yes, thanks. I'm also now trying to get some body camera footage, and I got the consent from the subject of the video, but they're still trying to throw up some roadblocks.
Yeah, I mean, feel free to contact me. I'd be happy to get into the specific. Can you elaborate? Like, what are the bases that they're claiming?
Well, I'm the person who has, they're saying that there's a BIA investigation and that it was open 18 months ago, and they're still trying to say that that's the reason why they withhold the information.
Yeah, thanks for clarifying that. When I was answering that, I was thinking about like actual criminal investigations. If we're talking about an internal investigation, I think courts are going to be a lot more skeptical. And with 18 months going by, the idea that it's going to interfere with the investigation, even if it is open, I think you're in pretty good shape. Generally, what I found is that when it comes to internal police investigations, most judges want to see as much released as possible. And so that's good, right? So track record is pretty good. If we're talking about unsolved crimes, then courts, it's the opposite. Courts are very protective of trying to not want to put anything out in the world that plausibly might interfere with the investigation of an unsolved crime. So it's very, very different kind of scenarios. So I think from what you're describing, I mean, you probably have a pretty good case against BIA and CPD for withholding the video from what you're describing to me.
Well, when I first asked for the information last year, they said that, they needed to interview the police officers.
Yeah.
And so, it's been a year. So, and now they're still trying to say this so-called investigation is still ongoing.
Yeah.
So
I've seen this movie many times. And I can tell you that, yeah, we just not always, but generally we're able to prevail in those.
Okay, all right. Well, I have a request for review and play, and we'll see how that goes.
Great.
And if maybe you'll hear from me if I get another denial.
Happy to talk anytime.
Thanks.
Okay, well, thank you so much, everyone, for your active participation today. This has been a really awesome discussion. Again, our panelists will drop their emails in the chat and are happy to, if you want to follow up with any other questions. I will follow up tomorrow morning with the recording and the slides. Thank you so much for staying connected with us, and we hope to see you at future events.